Good morning, afternoon, evening, or if there's some other time of day, twilight, dawn, whenever you watch this. Greetings. Hope everybody is well. Wanted to bring everybody up to speed as to where I think we are and my own encounters with the receiver, the receiver's counsel, etc. And I saw I'm looking at the people that are commenting. I'm going to say hello quickly to them. Hello, Mr. StreamYard. I don't know if anybody gets that joke, by the way. White Horse. What are your thoughts about John Forster's post? Which post? I don't know. I have communication with Mr. Forster, so I kind of generally know what he's thinking about, but I don't know which post you're referring to because he posts more than one. Hello, Epic Toe Cramp. Not Epic Toe Cramp, but Epic Toe Cramp. Brett, technologically spastic, but you put a hyphen between the two, which means you're not technologically spastic. Frank, the 1-1 boat bum. I like that one too. Hope everybody's well. I wanted just to, I hadn't spoken to you guys for a little while. Hi, Jason. Hadn't spoken to you guys for a few days. And again, like I said, I will keep you apprised of what's going on, even if there's nothing going on, just so that you don't feel like you're kind of lost and don't know what's happening, because I know that feeling and I know that's not fun. So this way, even if there's nothing going on, you know there's nothing going on. And if there's something going on, you know that too. And I got some other stuff to discuss about that. Before I get to that, though, I just a couple quick things I wanted to go over. And you'll kind of gather what I'm going to be talking about by these things, I hope. What is black and brown and looks really good on a lawyer? A Doberman. What's the difference between a lawyer and a vampire? Law school. And again, of course, there's exceptions to the rule, including yours truly, but these are jokes or attempted jokes. The lawyer's creed. A man is innocent until proven broke. And last but not least, I thought this was a funny one myself, but who's accounting for taste? What do lawyers and sperm have in common? A 1 in 3 million has a chance of becoming a human being. I thought that was funny. Anyway, so what I wanted to do was to bring you up to speed as to what's going on. And by the title, you might note that I wanted to talk about the receiver's counsel, etc. And we can go from there. So I'm just going to jump into it. So I've reached out to the receiver's counsel, and let me preface everything by saying, so the receiver's counsel, no reason to suspect they're not going to complete this and do a great job, whatever. I've not received any information to that, subject to the caveats I will discuss. But as far as I know, they're doing a professional job and whatever. Does the fact that the receiver was not a professional receiver, would I prefer that he was a professional receiver? Yeah, in retrospect, yeah, he may be a little non-aggressive and for my likings. But be that as it may, it appears to me they're generally doing what's needed to be done and moving in a positive direction. Now, so that's the preface, and hopefully they'll be successful. They get all those shares returned, and the deal will be completed, and we'll move on from there. And maybe that'll happen this week. Who knows? I've no reason to suspect that things aren't going to move forward. When and where and what the conclusion will be, I don't know. But I've no reason that we're not going to advance. But as time goes on, and kind of an effort to kind of understand what's going on, and an effort to kind of me to be able to tell you what's going on, I communicate with, or try to, is better frame, try to communicate with the receiver's counsel. And I find this an unusual situation because I helped with a bunch of other plaintiffs get the receiver appointed. And since his appointment, it's like I haven't taken a shower since then. and he keeps his distance. And although he was certainly working with me to get his appointment, since then, I can't say that's been the case. I don't think there's any necessarily, negative connotations, but it kind of, that would certainly be a criticism I would have of the receiver, that his contact with someone who assisted him at the beginning has been non-existent. I'd also critique his performance to date, that he doesn't post on the X site. He doesn't provide enough updates. His counsel does not provide enough updates, which causes, and again, that doesn't necessarily mean there's anything negative per se about it, but it's thoughtless because it keeps the shareholders in the dark, shareholders who've gotten screwed in the past. And it would be much more thoughtful and appropriate if the receiver had the courtesy to notify shareholders about things on a more regular basis and in a timely manner. And that same thing goes for his counsel. And I have more to say about his counsel as we go on. So that's my second criticism. My first criticism is that lack of experience and lack of aggression. Second criticism is a failure to provide what I think is adequate information to shareholders and to ignore shareholders. Like he's concentrating on his task separate and apart from the shareholders. Again, could result in a great result, and I'm not saying it won't, but it's annoying and it's disrespectful to shareholders. And that's not new. It's not a new statement. Let's just say that. Then we have the receiver's counsel, and I'm gonna give you the opportunity to express yourself. We'll get into that later down the line. Receiver's counsel, since their involvement, has been no particular friend to me, and they haven't been open, transparent, respectful. That doesn't mean, again, that they can't do a great job and the result can't be great. I'm just telling you about my own personal relationship. No, they gave no credit for my prior involvement. Not that I need credit, but it has to be in context, which led to, if you recall, so I have to put this out so you understand, if in my comments, if I make negative comments, you have to understand where my prejudices might come also, to be fair. So I was sued for defamation by Reichman and Rabari because I accused them of misconduct in a very general sense. Obviously, my accusations were more than accurate, whatever. So eventually that defamation action was dismissed because it was a bullshit action. Now, it wasn't dismissed by, what it was dismissed by was, once the receiver was appointed, once I think he had already submitted a report, he had determined all kinds of misconduct. Once the receiver was appointed, then eventually his counsel dismissed me from the action. So it was literally GTII's counsel, which is the receiver's counsel. Now, I thought they dicked around at that time. I thought they didn't act appropriately, especially in light of the fact the receiver not only bolstered what I said, but expanded upon it. And all my videos are based upon the receiver's findings, not my own. So I thought they dicked around. And from that point in time, I was not a fan, although I did not express that out loud, because the greater purpose was for the benefit of the shareholders. And that's been multiple times where I've gotten annoyed beyond enough, but I've retained it because it's not important to the ultimate conclusion. The reason why I'm talking about this today, because I think it might be. So that's the reason why I'm bringing it up today. So I've had a lot of interactions with the receiver's counsel, including early on. I spoke to him, and this is Dylan Siciliano. He's one of the attorneys, Ciciliano, Dylan, Dylan. He had the audacity to say he didn't trust me because my motivations were not money-based. So, I'm doing this, not like I don't have stock, but I've already told you, in my mind, I wrote the stock off as zero, and then I'm operating whatever. And I came from MMTLP, where a bunch of shareholders got screwed. So I had enough of that. So I decided to see if I could assist. So this, I'm going to leave the expletive deletive, tells me in a conversation he doesn't trust me because my decision wasn't money-based. I mean, if he was in front of me, I'd probably slug him. But we went on. And then since then, I've asked them on repeated, countless times for information, for the status, for all kinds of things. I asked to be included in the mediation. I asked to be included in depositions. During one of the court appearances where I traveled from Southern California to Las Vegas, without giving me any notice, by the way, in court, this gentleman, Mr. Siciliano, at the very end of the hearing, requested the court that I have no ability to participate in proceedings. That's not exactly what he said, but in effect, that's what he indicated. So this is after I come from California to this hearing, and this gentleman at the very end of the hearing, without any notice, asked the court, basically trying to prejudice, and I didn't even understand the point, but try to prejudice the court or get autonomy or independence. They obviously, and I can recognize this, attorneys don't like somebody looking over their shoulder. And these gentlemen, whether they're operating, whether they're doing a great job or not, do not want somebody who has any level of sophistication to look over their shoulder. If that wasn't the case, they would have already capitulated or called or responded in good faith or not acted like dicks like they have to this point in time. So after that experience, I'm sure I expressed myself to counsel that I wasn't very pleased by that particular action. But I was informed somehow that a mediation was going to go forward. And I think I've mentioned, a bunch of subpoenas went out. So the mediation, I asked to be included, but instead of including me, they went forward with it. Instead, and I have no idea what the outcome was because they have refused to disclose the outcome. I've asked them repeatedly, and it may not be complete. It's possible, or it may have been concluded ineffectively, or it may have been concluded positively, but we don't know because they haven't disclosed that, and no 8K has been filed, and they have consistently fallen on the position that material non-public information can't be disclosed. So anytime I ask them a question, they say, this is what they say: it's material non-public information, we can't disclose it. So my point is, so make it public, so it's not private and it's not material. So I'm asking, like, the status of the mediation. Is that material non-public information on a stock I can't trade? So what's the logic in that? The issue about not disclosing material non-public information is about trading. As far as I know, I can't trade that stock. As far as I know, when I say as far as I know, I can't trade that stock. But they use that every time. And this is, again, Mr. Siciliano says consistently, material non-public information, I can't tell you. Now, I know he spoke to plaintiff's counsel before and probably disclosed, or, I mean, I don't know what they talked about because I wasn't a participant, but I know they spoke. And I guess he could have used that same premise then, but he elected not to. But now he decides that anything I ask is material non-public information, and they won't disclose that. So what does that cause me concern about a lack of transparency? It absolutely does cause a concern about a lack of transparency. And pisses me off, by the way, besides the lack of transparency. So, and we also don't know what went on in the mediation. Don't we want someone, a shareholder's perspective, even if we can't participate in the negotiations themselves? But wouldn't you guys want, and it doesn't have to be me, it could be somebody else, I don't care. But wouldn't you want somebody to at least for 5 minutes to speak to the mediator and give the perspective of shareholders? Because obviously the Receivers Council does not give the perspective of shareholders, gives a perspective of the receiver, if the receiver knows what's going on. But wouldn't it be nice and appropriate if somebody, a shareholder, could advise the mediator, for example, listen, Mr. Mediator, I know I appreciate you. A mediator, by the way, is somebody, it's a third party that acts as an officer to try to resolve a dispute. And in this case, the dispute would be about the return of shares. So this would be like Reichman, Justine Reichman, Kathy Griffin, whoever else, because I don't know who's the parties because they haven't disclosed that either. But will they return their shares? And I would think, and I don't know what the discussions are, and there's all kinds of reasons why you might let them retain shares because it might be cost effective, might take too long. But wouldn't it be nice if the receiver heard from, if the mediator, the party who's going to be dealing between the parties, and the party that would be able to tell, for example, Reichman's counsel, that, listen, I've heard from shareholders, and if this thing doesn't go well, you guys are going to end up in jail. So I would think that would be powerful. Now, I know that I presume, I don't know, in Nevada, in California, in a case in California, an attorney can't use a threat of criminal prosecution to gain an advantage in a civil case. I don't know if that's the same rule in the state of Nevada. So there may be a justification why the Receivers Council can't say that. But isn't that more reason why a shareholder shouldn't be there just to give a little color to the mediator so the mediator can properly present the issues to both parties? And they went forward and excluded me, and I don't think anybody else went. And I don't even know when it was, where it was, how long it was there, who was there, what occurred, and that has been not disclosed. And that is entirely lack of transparency. And we have no way of monitoring if the negotiations were conducted in good faith, if the Receivers Council was representing the interests of the shareholders of the company in good faith. We have no reason. How would we know? We weren't there. We were excluded. The second part is about depositions. So if in fact, and again, I don't know, but if in fact the mediation went forward and didn't conclude, or has concluded but hasn't resolved, and the case is going forward and there's going to be depositions, isn't it appropriate, especially from the judge who said that the shareholders have to be considered? And even in the live hearings, I think that were broadcast by JR, in open court, he referenced it clearly that the shareholders' interests have to be strongly considered. So I volunteered. I'm not getting paid for this nonsense. I volunteered to attend the depositions if the depositions are necessary. And in the last communication I had from Mr. Siciliano, he, in a long-winded fashion, said, "Nah, you're not going to be able to attend. It's a claim of, obviously it's a claim of the receiver, but the receiver could let the shareholders attend. It's clearly a lack of transparency again. And does that impact the ultimate outcome? No, but does it cause me concern when parties are doing things behind the scenes without any clarity and transparency? Yes, it does. Does it make me question them? Yes. When their motives are only money-based, does it make me question them? Yes. Why do I say that their intentions are only money-based? Because when the guy told me that he didn't trust me, because he didn't trust people when their objectives weren't money-based, That leads me to believe he's projecting his own understanding and belief system. So these attorneys who represent the receiver don't seem to be interested in the shareholders. That's my view, my opinion. That's based upon my interactions. And it's possible that now my interaction with Mr. Siciliano has gone so far south that he won't do anything, even if it's appropriate. That's in the interest of shareholders. But we aren't going to let him go out. I'm from this point in time, whatever scrutiny I gave of these gentlemen and whatever I said publicly will not be withheld, will not be colored, will not be restrained, unless I think it will damage our position in the lawsuit or in recovering against the scumbag Reichman and all that clan of scumbags. I'm not going to do anything to jeopardize that. But as far as I know, there's nothing I said that negates anything that they've done. I'm talking about their tactics, their dealing, their transparency, their interactions. That's what I'm talking about. And just as an example, I'll give you, oh, and by the way, so I'm just going to throw this out. So to the extent that anybody wants to voice their opinion to the receivers, to the receiver, you could certainly do that, or to the receiver's counsel. And I ask that if you contact anybody, that you do it in a civil way. You don't use any don't scream at anybody. Don't use me as an example. Don't use curse words. Just just communicate the point that if you want shareholders to be included in mediation and future depositions, that you inform the receiver's counsel and the receiver of such. If you think they've lacked transparency and you'd want more transparency, communicate that. And I'm going to give you a telephone number for the counsel for the receiver. And I'm doing him a favor by not giving him, I have another number that I'm not going to disclose. So when he gets pissed off that a bunch of you are calling, I could have made it a lot worse. But this way you have an opportunity to communicate your feelings. And if you don't agree with me, then don't. But if you want more transparency, if you think somebody from our group should be at the mediation, if you think somebody from our group should at least attend the depositions, then communicate that to the receiver and the receiver's counsel. At the receiver's counsel is area code 725-777-3000. The attorney that I'm dealing with is Dylan Siciliano. The other attorney that is that has treated me in a more civil way, I would say, is William Knoll. And he's the older, if you've watched any of the court proceedings, Mr. Knoll is the more senior of the two. Mr. Siciliano is the younger of the two. But if you feel inclined, communicate that or anything else you want, or don't. If you don't feel inclined, don't. If you feel differently, communicate that. But do it in a civil way. We want to be taken seriously. So to be taken seriously, you communicate your ideas in a civil manner, concisely and briefly, and then you move on. And you keep track of when you have those communications. And again, there's no reason why I don't understand why the receiver hasn't communicated more generally, not on his X feed, why there's not been, if there's so much non-material information that can't be disclosed, at some point in time, where are the 8Ks? Where are the disclosures of that non-material information? It doesn't make a lot of sense to me. Again, in the grand scheme of things, though, it doesn't mean that the outcome is going to be any different. I'm just talking about interactions, the style, things that give me concerns, especially with these guys being the Reichman clan. And that's kind of what I wanted to say. So I'm going to leave you in my most recent interaction I had with the receiver's counsel. So I'm asking about basically, this is my last reply to Mr. Siciliano. And I'm asking about being able to be in the mediation and also to be able to participate in depositions. And his response is, I'm going to read the response so I don't misquote it. I got the response yesterday, which encouraged me in part to do this particular live stream today. And again, I could have really, there's been so many times where, notwithstanding whatever was going on, I was pissed and I could have reamed these guys, but elected not to. But you'll see that time is now past. So I ask, I want to be involved because I've asked, and I might send it out every day, literally. I don't tell you guys I do it every day, multiple times, but I do. I'm annoying. That's the idea. If someone doesn't respond to you, you got to be persistent. So I asked to be included or whatever. His response, make sure I have the right thing here. I thought I had the right. Oh yeah, okay, I got it now. So I can read it in order. Sorry for the delay there. So my email to him is yesterday morning, 9:14 a.m. I've asked before to be included in any mediation and depositions. I certainly have not been included. And then in parentheses, I say, what right does a receiver have to exclude a shareholder on a matter affecting the shareholder's interests, with 4 question marks? And then close parentheses, and have no idea, as do any of the shareholders, of the status of the mediation. Is it over, ongoing, any progress? Certainly has been ever frustrating to me trying to pull information from the receiver. Again, I cannot trade the stock anyway. Signed, a very annoyed shareholder. Be well, and then R. The response I received a couple hours later, Richard, the claims being mediated belong to the company as agreed to by plaintiffs and are owned by the receivership estate. The receiver has a sole ability to resolve the claims. As we told you, the receiver, to the extent the claims are settled, will seek court approval. As we explained, will either resolve claims or likely amend the complaint. As a shareholder, and without regards to the receivership order, you don't have the right under the bylaws to participate in the mediation. That's reserved to management and otherwise covered by the mediation privilege and subject to the receiver's business judgment. Once the litigation stay is lifted, to the extent you have claims or standing to pursue claims, you have the rights of any litigant. What is occurring now is part of the receiver's investigation. However, there's no general right of shareholders to attend depositions. So before I go, I'll go to my response, just not to kill the continuity. So I responded about 30 minutes later to Siciliano, William Knoll, and another attorney that I've never had contact with. My response, honestly, pretty unhelpful, vague, and non-responsive, as much of your communication or lack thereof has been. In my opinion, you could have handled our relationship differently, but so be it, that ship has sailed. If you follow any of my videos or posts, you will note that I've held off attacking the tactics of the receiver's counsel vis-a-vis my dealings with your office, parentheses, despite your communicating information to plaintiff's counsel, which you would not and will not communicate to me. Have a good and productive day. You do not need to waste estate funds responding to this, and I wish you good luck in your strategy. That's my last communication with them. And I'm sure I will reach out, but I have no interest in engaging in further discussions. And you notice their response was they cited the business judgment that's so the receiver, if the receiver wants a shareholder to attend, they obviously can. That would be a judgment of the receiver. And there was no explanation why. They told you what they would do. Either the claims will be settled or amend the complaint. They gave no explanation or reason why a shareholder shouldn't attend the mediation. Completely ignore that. In the end, they say There's no right to for shareholders, no general right of shareholders to attend depositions. I didn't say there was a general right, but you can allow that if you choose not to. What reason do you have not to let a shareholder attend? Not ask questions, not to say a word. What reason do you not have? What reason do you have for not letting shareholders attend a mediation in which they're the damaged parties? Makes no sense. And this is nonsense and further nonsense. This is just a one. I just use this one because it's the most recent one. This is the kind of response I get. Bullshit responses that are not informative, non-transparent, and are annoying. And they're getting paid for it. It's not like they're doing this for free. They get paid for not responding. The receiver gets stock and money. Anyway, you get my drift, right? So again, I'm going to repeat, and I'll give you the number again. They used to have when I was a kid, they used to have wrestling, the different kind of wrestling, fake wrestling, and roller derby. And the guy was the announcer. He'd repeat the number, like the telephone number, multiple times. Richmond 9 5171 5171. So if you want to express yourself in a nice manner to the Receivers Council, to encourage them to let a shareholder participate in mediation and deposition, at least attend depositions, not participate, or anything else that occurs to you, you can feel free to communicate that to the Receivers Council. I think I gave you two names, Dylan Siciliano, that's Ciciliano, and William Knoll, Noall. Mr. Siciliano is the one that I've had most of my negative remarks about based upon our personal dealings. And the office number again is 725-777-3000. Again, if you call or if you communicate with them or with the receiver, do it in a civil manner so your opinion is counted. So the extent you express something, that it's counted, it's taken to an account, and it's not just some person yelling at somebody. Again, you could say, for example, I'm not encouraging you to say this, but you could say, listen, I'm a shareholder of GTII. Please, I'm calling for Mr. Siciliano. Please let him know that I want shareholders of GTII included in mediation and depositions. And anything else you want to say, or something else, or you don't have to do it at all. But that's what you could say. And you could pass on the same information to the receiver. You could ask for more transparency, more reporting, more disclosure, more clarity, more aggression, whatever. Some people may want to, I know a lot of people would just rather Reichman go to jail. They want that, but usually they're mutually exclusive. If they go to jail before you get their money, you probably don't get their money. So I'm all for those guys going to jail, but I want to get their money for you guys first. So that's kind of in the head. That's kind of how we're thinking. And that's where we'll leave it. So to all you out there who went through this, I appreciate it. Feel free to communicate in the civil way or not. Again, nobody's forced to do anything. And I really mean that. If it's uncomfortable to you, if you feel manipulated by me, if you feel squeezed or whatever, then don't do it. If you feel that it's in your own personal interest, then please do that. Or whoever else you think, or do whatever you think's correct. I will see if we get may get some kind of response from this. I don't know. We shall see. When I have some additional information, I will let you know. I don't see any. I looked at the court portal today. There's no hearings currently scheduled. There's a bunch of subpoenas that were sent out by the Receivers Council. As far as I know, they have not yet been responded to. Probably like 40 or 50. And some of them, I think, were follow-up subpoenas that were issued before. A lot of it was bank subpoenas where they were trying to get financial information or information with regard to purchase of a stock, whether they were legitimate or they were coming from, et cetera. All that I have, I think that's all proper and appropriate. And that would be used if depositions were occurring. Then you'd take some of those documents and you'd show them at depositions, ask witnesses questions, et cetera. Okay. That's all I got to say. For all you out there tolerated this, I appreciate it. All of you be well. May have some more. If we have more information, I'll let you know. I do expect to speak to Mr. Forrester in the next few days. We are on very good terms, and we communicate occasionally, but on a regular basis. And if I have any additional information, or if anybody else has additional information, feel free to post it. Thanks again. Have a great day. Be well, everybody, and take care. Yes.